number 107.
That was very good, Judge Moore.
Oh, yeah, right. Goldsmith.
Thank you, Your Honor.
Mr. Goldsmith, I'd like to ask you this preliminary question, and it has to do with the question of where the sole issue on appeal is the amount of attorney's fees, the extent to which there may be a conflict between the attorney and the client. If Frankel wins this appeal, who pays the costs, you or Fríoló?
Well, Your Honor, this court previously, and we were here before, asked that the fee agreement between the lawyer and client be submitted in the record on remand, which it was. It's an hourly fee agreement, such as any other hourly fee agreement. So, pursuant to the agreement, there is a client who's responsible for the litigation. I'd like to add to that, though, that
so in other words, if the fee is increased, or if we were to, whatever we do, if the end result is an increase in the fee over what the circuit court ordered, that is going to redound totally to the client's benefit?
That's correct. Okay. That's correct. And let me add something that I would really like to focus my argument on a little bit, if I may, which is that I believe that in briefing this matter this time around, that I dramatically underplayed the significance of this court's prior decision in Pak versus Huang, because I believe that the scenario, really what's happened here is that the Court of Special Appeals held that Ms. Fríoló, in fact, wouldn't benefit from an award of fees for the litigation that occurred before this court on appeal back in 2002, 2003.
We didn't know at the time what fee agreement, whether there was a contingency fee agreement, what it was.
Right, and what the court in saying that, in fact, the Court of Special Appeals in saying that, in fact, really went directly to the contrary of what this court held in Pak versus Huang, because once one very carefully parses and compares the facts and the ruling of this court in Pak versus Huang, this case requires application of the exact same principles to a set of facts that's actually more sympathetic than the facts that this court found sufficient to warrant a remand that would allow for fees. And let me specify what I'm talking about for a moment, if that would be okay. The Pak versus Huang case was one in which the plaintiff actually had received payment of all damages and had received a payment for attorney's fees, which has never happened in this case. That plaintiff had received those things before going up on appeal. The reason that there was an appeal was that there was a need for supplemental attorney's fees because the plaintiff and her counsel had needed to perform work in order to be enabled to recover the initial judgment, both for fees and for damages. This court recognized that the need for both the fees and the damages was something that should be compensable when an appeal was necessary in order to enforce those original those rights stemming from the original litigation. It's the exact same thing that's happened here. Ms. Fríoló, while she did receive a payment for the underlying damages, had received nothing for fees, and in order to recover the underlying damages, there had to be attorney work involved. That was the purpose of the appeal.
Well, she did get a fee award initially. either she or you or both of you were unhappy with it, took an appeal, and we sent it back saying, may not be anything wrong with the amount, but you need to use this sort of modified lodestar. Your methodology was wrong. Go back and use the right methodology.
That's right, Your Honor.
You can come out the same way if you want.
Absolutely, Your Honor. That's my understanding of the ruling.
And you went back and you got a higher fee. But that wasn't enough. Now, if it's on an hourly basis, or she is financing your fee.
Your Honor,
she has gotten all she's ever going to get compensatorily.
Your Honor,
is that right?
Well, Your Honor,
she's financing your fee.
In order to obtain any fee, a certain amount of legal work had to be done. The trial court made an award for that. This court had its ruling. It went back on remand. The trial court said, we're going to, based on this court's ruling, we're going to increase that award, but it awarded zero for the appellate work that was required in order to get the initial incorrect ruling corrected. So in that instance, we're in exactly the same posture as what happened in PAC. And indeed, in PAC, when the case came before this court, the court had an opportunity to use grounds related to contempt and misconduct and so on by the defendant in that case as a basis for its holding for awarding such appellate attorney's fees, and it declined to do that, instead emphasizing heavily the statutory issue, which is really at the heart of all of this, which is that the question, anytime a question pertaining to a request for fees under a remedial fee-shifting statute comes before the court, the question is, was the work necessary, and was the effort that was put forth successful to achieve an important result?
If we were to affirm the Court of Special Appeals in this case, would she still owe you for those appellate fees for the last case and for this case?
Under her contract, she would, because all of that work was work that was done in order to obtain the proper remedy under the statute as it exists. She never would have gotten the benefit of her litigation at all had she not undertaken the appeal in Fríoló 1, which she won. She would have been in a position of having $50,000 in fees for having won an $11,000 judgment. She needed to seek fees when the trial court reached a decision on that was in error based on an incorrect methodology.
That raises another issue. In the first Fríoló case, we said where you're fee shifting, you take a more liberal look at the ethical rule that otherwise would apply between attorney-client, because it's fee shifting, and there's a public policy involved in the statute that permits fee shifting. Defendant pays plaintiff's fee. But if you're in a situation where your agreement with her is that she's going to end up owing you $50,000 for an $11,000 judgment, that's between you and her. It has nothing to do with
Absolutely, Your Honor. That's clear from the precedents.
You may have a problem.
Your Honor, if we were before the court on a – well, let me put it to the court this way. I'm entirely mindful of obligations related to professional responsibility. We're not here for that purpose. I went back and studied carefully the authorities in fee-shifting cases and the discussion of the various factors, the Johnson factors, or in Maryland Rule 1.5. There is no precedent, no significant authority for the idea that what we are here for today is to adjudicate whether Ms. Fríoló is being treated correctly by her counsel. The reason
it's implicit, though. It's implicit is my problem. You now have – you started out, you said a $50,000 fee for an $11,000 judgment. Some of that was shifted. I can't remember in the first case what what Judge...
he awarded 40% of the judgment, which was $4,700.
So you're only talking about the difference there. Now you've got on top of that 2 appellate proceedings, plus the trial, the second round at the trial court. You had the first appeal back, second proceeding, now you got this. On an hourly basis, all these fees are adding up. And if you lose, you're saying she's going to owe you all this money for 2 appellate proceedings and the remand, and get nothing out of it.
This court stated in Fríoló 1, Judge Wellner, Your Honor's opinion, that the purpose of the request for the fee agreement between plaintiff and her counsel was because the fee agreement may be interesting for the court in order to make sure that the award to the plaintiff and her attorney isn't higher, greater than what the lawyer would have been entitled to bill for in the first place, okay? That question, the question of what is an appropriate amount for a lawyer to bill, the case law in that area is not focused primarily on a question of whether a plaintiff should bring a certain kind of case that in this case is highly recommended by the legislature through its remedial legislation. There's no authority for the notion that Ms. Fríoló shouldn't have brought this case because it would be too expensive to prosecute. No authority for that at all. So in the absence, thank you, Your Honor. In the absence of that kind of authority, the only way that the purposes of the legislature can in fact be vindicated is if this court remands this matter again with very clear instructions that if the plaintiff in a remedial fee-shifting case, such as one under the Security Deposit Act or the wage payment, it doesn't matter, the fees are shifted to the extent that they are reasonable for the work that was needed in order to obtain the successful conclusion. If it's unsuccessful, there's no fees at all.
If we remand this back for the trial court to reconsider the fee issue, then this appeal will have been successful. And if the trial court doesn't award what is felt to be the appropriate fee, then you can appeal that back up here again. How many appeals are you going to be able to take up in a case involving only attorney's fees where the client got $11,000?
I think that's a very important question, Judge Cathell. I would say this. This court has issued, in my view, 3 very important decisions in the last few years on fee shifting. I've already mentioned POC, obviously Fríoló 1, and the third one is the Flaw case. And in the Flaw case, the way I read what this court did was that it made it very clear that the trial judge has a lot of discretion. And if the trial judge applies the general rules or the framework that has been laid down for it, it'd be very difficult for either side to appeal. In this case, in fact, the initial appeal now was brought by the Frankel parties. We cross-appealed.
You misspoke. It would be difficult if that occurred for either side to successfully.
That's right. And if it were unsuccessful, then in the case of the plaintiff, there would be no fees for that. And that's clear. That's fee shifting.
I don't know. If you're on an hourly basis, that would be true on a contingency fee. You say you're on an hourly basis.
Well, to the extent that there would be no shifted fee.
Oh, no, shifted.
There would be no shifted fee. Therefore, the incentive is always there for a plaintiff in one of these kinds of cases, which are always, almost always low damages cases. They always require relatively large amounts of attorney time in order to vindicate the purposes of the statutes. There would be no incentive to bring another appeal if the trial court appears to have applied the factors correctly. And unfortunately, this time around, they appealed, we cross-appealed on the fact that there were no fees awarded for the appellate work whatsoever, which is, I must emphasize again, is directly contrary, the same kind of fact scenario as the POC case, directly contrary to that. And the Court of Special Appeals missed that, in my judgment, in its holding. So were this case to be remanded and the framework basically applied, it would be very difficult to successfully appeal, which in itself is a disincentive to the plaintiff to appeal. I would have hoped it might have been a disincentive to the defendants, but they, in fact, appealed the last time when they didn't like the precise amount. But I think that it's very important to recognize that this case follows right on the heels of that other case, and the posture, the Court of Special Appeals made a particular point of teasing out this particular posture of this particular case at this particular point and saying that there can't be attorney's fees except pursuant to a particularly strict three-part test, ignoring the fact that this Court had already made issued a judgment, an opinion that had said that appellate attorney's fees were available for an appeal of only an issue of attorney's fees in a fee-shifting case 4 years ago. And I believe that case, that the Court should follow the reasoning of its own decision there, because I think the reasoning was sound. And the questions that the Court is posing to me that I think are excellent questions about the implications of what will happen if the Court rules in a particular way. Many of those questions can be resolved down the line by the further explication of exactly what's expected of the trial courts. It's no secret that in our state there's been a wide disparity in the way trial courts have ruled on these issues over the years. And it's unfortunate for everyone involved that this litigation has gone on for so long with appeals and so forth, but that further explication by this Court will make future cases less litigious, less difficult, less requiring the attention of this Court or the Court of Special Appeals, because the standards will be better understood. And I think it's that's really a central issue that should respond to some of the questions about process and questions about what's going to happen in this particular case.
At the circuit court, when this case went back, did the circuit court, I know what the Court of Special Appeals said, did the circuit court say that as a matter of law, attorney's fees at the appellate level first time around were precluded? No. Didn't say that?
No.
It just made an award.
The Court was, the history of it is that it made an award. The numbers in the award made it very clear what the point was, which was to compensate the plaintiff for the fees that she had incurred during the trial stage. Objecting to that, we filed a motion for reconsideration. Objecting to the amount that was awarded for the trial stage work, the defendants filed their own motion for reconsideration. And in ruling on those, in our motion, we've made very explicit that our concern is that it appears that there has been no award for appellate work whatsoever, and that that's contrary to the law. And the trial court denied both sets of motions with no comment. So having failed to comment on it, we were left with having to try to, I would just say that we concluded that what we thought had happened had indeed happened, and that was the error that was made, and that was the basis for our cross appeal. In addition to standing on the shoes of the POC decision, there's a couple of other things I'd like to point out to the Court in the remaining time. One is that a defense has been raised before this Court to the fees that goes something along the lines of the Frankel party shouldn't have to pay because they've behaved in good faith over time. They've not done anything to warrant what may wind up being a large attorney's fees award against them. I'd like to point out that that sort of argument, first of all, is completely contrary to the legislature's intent, that the statute says nothing about bad faith, good faith, parties, defendants who have stronger defenses or defendants who have weaker defenses.
But I thought that issue had to do with the distinction with POC in the sense that in POC they didn't satisfy the underlying judgment. And here, as I understand it, Dr. Frenkel has. So I understood that distinction to be in that realm.
Well, to the extent that it might have been, that understanding of the facts is incorrect. And I didn't do a good enough job in my briefing of bringing that out before the court's attention. The underlying judgment was paid in POC. And in fact, that judgment included attorney's fees, which this judgment never did. That judgment was paid right before the hearing on the contempt or whatever the procedural motion was before the circuit court. And nonetheless, the fees that had been necessary to get that enforcement done, which is what we were trying to do here, and the fees that were necessary, that were going to be necessary in the future on appeal in order for the earlier work to be vindicated and the plaintiff to get the benefit of the result that she was entitled to, all of that was deemed compensable by this court. It appears my time is running out. Are there any other questions right now? I'll yield to counsel.
Thank you, sir.
Thank you.
Mr. Focht? I hope I got that right.
It's close, Your Honor, but pretty close.
You know, I'm going to stop trying. I'm 2 for 2. They are tough.
Like with the other attorney, you got it close enough that it wasn't uncomfortable.
Thank you. Okay.
Thank you, Your Honor. Matthew J. Fote for Dr. Frenkel. May it please the court. I think we've keyed in on the POC case, but there's one other case that needs to be talked about because it's one that both sides have cited, and I think it's very helpful here, and it's the Third Circuit Prandini case. And this case is essentially the corollary to the Prandini case. Prandini case says where the opponent has made the additional work necessary, the appellate fees should shift. It's their fault. They did it. This case is the flip side of this, where, I was talking about this case the other day, and it's really a once-in-a-lifetime, stars-aligned kind of situation where we've had a trial, a fee award, an appeal, a remand, a second fee award, a second appeal, and then a vacation of that fee award. So really, we're at a bit of a disadvantage in this case because the fee award has been vacated. So the matter of how much has been earned or how much has been awarded in attorney's fees, that is kind of up in the air right now because in Dr. Frenkel's appeal of Friollo 2, his portion of it was that the instructions that this court gave in Friollo 1, they weren't followed. There wasn't a discussion of the Rule 1.5 factors and how Rule 1.5 needs to be brought into equilibrium with the fee award. There's no explanation of how the fee jumped up from $4,000 to $65,000, an amount that even exceeded the amount that was initially asked for, and an amount that this court said would not be a reasonable fee under 1.5. So it would be inequitable in every sense of the word for Dr. Frenkel to have to bear the burden of, one, having to get this additional clarification on the fee awards, and where the plaintiff thinks that they should have gotten more for their efforts. That's the corollary to Prandini, or at POC. I looked at just while counsel was talking, I looked at the questions presented in POC. And of the 4 of them, 3 of them deal with whether the defendant willfully violated court orders, supplemental attorney's fees incident to contempt powers, and then whether the circuit court has authority to enter supplemental attorney's fees pursuant to the Maryland Security Deposit Act. Again, that's going towards Prandini, where on some level the defendant isn't living up to their responsibilities. They're not paying the judgment. They're not acting, as counsel put it, in good faith, and that there should be a penalty for that. It's very interesting to me, and I noticed it in the briefing of this case, that a plaintiff is arguing against a rule that encourages judgments to be paid quickly. This rule says if you pay the judgment, not that there's no responsibility for attorney's fees, but where the judgment is paid, the plaintiff isn't going to get anything more out of it in their own behalf. It doesn't give the plaintiff's attorney.
Well, that may or may not be so. Let us suppose the plaintiff and her lawyer have an hourly rate, not a contingent fee, which is a reasonable rate.
Sure.
And the judge fines for the plaintiff, gives compensatory damages, but makes an award of an attorney's fee that doesn't cover the hourly rate, which is reasonable, but makes an award.
Right.
Now, if nothing more happens, the plaintiff is then stuck with the difference.
Right.
She's going to pay.
Right.
Your client doesn't. If an appeal is taken and is successful, in the sense that that's vacated, go back and redo it.
Right.
You're saying she's not entitled to anything at all for the appellate work?
Well, that's, I mean, that to a large degree.
Is that your position, number one?
You look at the rule that the Court of Special Appeals set out.
I say yes or no.
I would say it's not exactly my position now. The rule that the Court of Special Appeals set out in this case recognizes that there are incidents where appellate fees may need to be shifted.
So where no fee is awarded or a grossly disproportionate award.
Right.
Or outright denial.
Right. That gives the...
What does that mean? I mean, outright denial, that's easy.
Right. I think what you have to look at is, and again, it kind of ties into how we're at a disadvantage in this case. Client gets awarded $10 in attorney's fees just to keep it on really low numbers, because I need to do that.
Right. That's easy. I mean, but here it wasn't. It was what Judge Beard, I think, was the first time around.
Right.
40%
right.
of the judgment.
Right. Right. So 40% of the judgment.
And we said, now you got to calculate it a different way.
Right. Well, and it's an interesting point, because what that's going to is not, and it's what the court brought out in the Fríollo 1 decision. It's not that the amount is necessarily wrong. It's that how you got there. You got to, like elementary school math, you have to show your work. That's not a fee that should be shifted. That's a technical that's a methodological.
Well, suppose when it went back like it did here, he says, all right, I'm going to do it the way the Court of Appeals told me to do it. I'm not going to tell you how I did it, but so now the fee is a lot more than that.
Right.
Which suggests that the original fee was not proportionate. Right?
Well, but at this point in this case, we don't really don't know that.
I don't know how he did it, but he concluded, well, last time I gave this, now I'm giving that after doing it the way the Court of Appeals told me to.
But the problem is that the decision is silent, and you can get there and say, well, the numbers kind of look close, so it may be that he awarded nothing for appellate fees. But there's never been an explicit finding of that. And that puts us in a real box. We're going based on something that we don't know what Judge Beard meant. And again, it would be unfair to shift that to Frenkel or to make Ms. Fríollo pay for it. I mean, it's a situation where the Court of Special Appeals rule is really trying to protect everybody, because on the one hand, fee shifting statutes, and this is the Pennsylvania Delaware Valley case, they're not intended to make plaintiffs' attorneys rich or to even replicate what they would get on an hourly rate. The purpose of the statute is to ensure that folks can get representation in these kind of cases. And if folks get that representation, then the purpose of the statute has been vindicated. And if that's happened, then that's good. But where you set up a situation where you can have, and the court brought this out, an appeal, I don't like that ruling, I think it's too low, I'm going to appeal it. Decision comes back, gets remanded, I don't like that ruling, I'm going to appeal it. And the problem is that it sets up a situation where you can have appeal after appeal after appeal, and all you got to do is win once, and all the appeals on the fees cascade backwards.
That's not really true, is it?
Well, sure.
That's not really true, is it? I mean, because then once it goes back, I mean, and there's a recomputation, this person runs the risk when he takes that appeal that he's not going to be able to convince the court that the trial judge did something wrong.
Well, I think
that's abuse of discretion.
Well, that's true, but
so that's not automatic at all.
Well, but your position is that if he wins the last one,
he just has to win the last one.
He can lose 4 or 5, but if he wins the last one, he's going to get it all.
He gets it all.
I don't think that's necessarily
true. No.
I mean, it's a tough position.
The whole thing depends upon the first appeal, really. It doesn't depend upon the last one. It really does depend upon the first appeal. That's where the rubber hits the road, isn't it?
The rubber hits the road in the first appeal because if there's not a quote-unquote bad decision in the first place, you don't even get to the appeal.
That's exactly
And
right.
that's why this case, when I said this was a once-in-a-lifetime situation, or I hope it's a once-in-a-lifetime situation, where you get a deficient order, goes up on appeal, goes back on appeal, you get a second deficient order, and it goes back and it goes up again, and now it's up in front of this court for a second time. If this court finds in favor of Friollo in this appeal, the fees will cascade backwards because the second appeal will be in error.
But in this case, the real reason for it has to do with something that the trial court did that really there's a basis for. If we said in one case, you've got a right to a fee,
right,
and implied at least that right to a fee includes appellate work, and the trial judge doesn't do it, I mean, it makes good sense to me to take the appeal. Now, that doesn't mean that every time the judge does a computation, so long as the judge touches every base,
right,
that there's going to be a basis for an appeal.
Right. Well,
or even if you do appeal, that there will be a basis for a fee share.
Well, but that's the problem is that if the rule that as it's being advocated here, as long as there is a win, or at least as far as I understand their position, is that as long as you win, and even if you win $1 more, you vindicated your right, and therefore you're entitled for the fee to shift in the whole amount. And that's why the Court of Special Appeals is...
I don't get that. Because his whole thought, as I understand the brief, he's complaining because he didn't get anything for the appellate work.
Right.
And he wants the judge to apply the same formula to the appellate work. That's what he's saying.
But you also appealed this time to the Court of Special Appeals.
We did, on the grounds that, and that is not in front of the court today, but we appealed
but
that.
They weren't the only. I mean, it sounds as though you're couching it that only Ms. Friollo appealed. They certainly had to deal with your appeal also. I mean, they are not the only people who have taken this up.
Well, from Friollo 1, which is where the ball gets rolling, there was no cross appeal in Friollo 1.
No.
The cross appeal only came about in Friollo 2 when we got the second order that basically didn't address in any substantive way what this court directed the trial court to do. And those were factors that would have mitigated, or at least to our mind, if they had been applied, they would have mitigated it down. We won that appeal and so now we're not appealing again. So now the only appeal that's ever been from Frankel against Fríola was just on that one issue that we prevailed on in the Court of Special Appeals. So the problem would be, you'd almost have to, if the court were to rule in favor of Fríola in this case, you'd almost have to segregate those fees out, because there was a complete and total victory for Frankel in that portion of the case.
Well, it really does depend on how it shakes out here, right?
Right.
Well,
because that's what he's done. He's appealed. Well, wait a minute.
But that's exactly my point about the fees cascading backwards.
Oh, wait. Well, there's always an issue there.
Yeah.
But he would not be entitled to any additional fees on any challenge that he was able to make to your victory. But he would only be able to talk about the increased fees insofar as they related to the appellate work that he was able to get the trial judge to consider in setting a fee. So maybe I'm missing it, but that's what I'm looking.
So would that be just Fríola 1?
No.
And there would be no fees for Fríola 2 or Fríola 3?
No, it's Fríola 1 and Fríola 2, because his whole point was he took the appeal in Fríola 1.
Right.
He won.
Right.
In order to get the fees that he was entitled to in the trial level in Fríola 1, he had to do the appellate work. And that, therefore, meant that he should get something for the appellate work that he did in Fríola 1 to get to where he wanted to be in the trial work. He wanted those awarded in Fríola 2. And when those were not awarded, then he has the right to appeal that aspect of the case in Fríola 2.
Right.
Which is what he appealed.
Right. But there's two problems with the way I understand what the court's asking. Is, first of all, that $65,000 fee agreement has been vacated. So we can't say.
So far.
So far.
Yeah, that's right.
We can't say so far that he's achieved goal X, because that's been vacated. And on remand, Judge Beard can look at this and reapply Lodestar, make the 1.5 adjustment, and say, oh, it should have only been $24,000, and I included X amount of appellate fees in there. If that's the case, then the whole landscape shifts. And so, to discuss it at this point, we're at a bit of a disadvantage. It's almost, this is our day in court.
Well, the Court of Special Appeals sent it back for Judge Beard to give his reasons and to be more explicit.
Right.
That was the only basis, as I understand it. They sent it back. Right. Is that right or not right?
Well, and then on.
Of course, they did say don't include any appellate fees. Right.
Well,
that's an issue.
Well, they didn't say don't include any appellate fees. They said here's your three-part test.
Here's the standards, right?
Here's your three-part test. If he meets it, he gets his appellate fees, and if he doesn't, then he doesn't. I mean, in theory, Judge Beard could say, well, I think this meets the grossly disproportionate standard, and that would be what it would be. And I guess that's the important point here, is that the Court of Special Appeals ruling in this case is trying to avoid a situation where the plaintiff and the plaintiff's attorney have essentially a blank check, for lack of a better term, to do whatever they want, and under the assumption that those fees are going to be shifted at some point if everything goes well for them. And what they're trying to do is protect the defendant, because they're entitled to equity and to protection under rules like 1.7 and 1.8 and 1.5, even if the fees are going to be shifted, and to protect the plaintiffs from being in a position where the attorney is reaching for the brass ring. I don't like that amount. I want to make some new law, and putting the plaintiff at risk of, if that falls through, they get presented with a bill for an hourly rate, like in Sterling. Sterling is a pretty interesting case that parallels this case in a lot of different ways. And it's not that the fee shifting sets up a conflict. It's the application of the fee arrangement, just like in Sterling, that presents a problem in this case. And that's why the Court of Special Appeals rule is very helpful, because it levels the playing field between plaintiff and defendant, and even between plaintiff and plaintiff's attorney. And if you have that equilibrium, particularly where the judgment has been paid, plaintiff has really nothing more that they can recover in their own right. That rule protects everybody. And if you have that, then decisions can be made on whether a case should be appealed or not appealed. But you need to have some rule that protects them. Otherwise, you give, with all due respect, too much power to the plaintiff's attorney to essentially take their shot to try and get more fees, take their shot to make new law.
But if you didn't have a fee shift, what's the rule?
If
if there's no fee shifting and somebody issues, the judge gives an award.
Right.
And you're unhappy with it, and you don't have a fee shift, there's a right to appeal because you're unhappy with the award.
Well, but
right?
here's the thing.
And the only issue is whether you get an increased amount. And, of course, there's always the question about the client and the lawyer and all that sort of stuff.
Right.
I mean, that's always there, but that's not an issue before the court. When the appeal is taken, the theory being that the client and the lawyer talked about it and they agreed.
Well, indeed.
So I don't understand why you need a rule in a fee-shifting situation when it is the discretion of the court in the first instance and in the final analysis which will determine whether or not there's merit to this appeal.
And the reason why it's different is because the plaintiffs and the plaintiff's attorney, and the plaintiff can sit down with his attorney and say, listen, I don't want you to appeal this case. It's over.
You can do that now.
But in the fee shift circumstance, you can't. The defendant has no ability to stop the process.
Why?
Because the plaintiff can always say, I want to appeal, I want to appeal, I want to appeal. And like we said, as long as they win at some point along the line, they're going to get their fees.
Not really what I'm saying. Well, I guess maybe I'm just missing it, but it just seems to me that in the final analysis, it depends upon whether or not the court crossed the T's, dotted the I's, and then use its discretion, its best judgment in setting the amount. And that person who then takes the appeal in that situation does so at his own risk.
Well,
and in fact, will probably be aware of the fact, because of what we've already said about the amount, that he's not going to end up with anything more simply because he took the appeal. And
Your Honor, I think we're not too far apart, because I used the exact phrase in my brief, proceed at your own risk.
Of course.
But the problem is that in the context of a fee shift, they're not proceeding at their own risk, because the fee is going to ultimately, at some point down the road, be paid by this other guy over here. So we can afford to be a little bit more loosey-goosey with what the decisions that we make if we think the fee is going to be shifted.
Only if you're right. I mean, just because you appeal doesn't mean that you're going to win.
Well, that's true.
And it seems to me at some point somebody's going to step back and say, well, this judge did this way. Did he abuse his discretion? No, I don't think he did. I'd better not do it. I just don't understand the reason for a different rule.
I think you're right. And I think in a perfect world, everybody's going to sit down, do their homework, do their due diligence, and say, is this the right call to make, and either make it or not.
This case, for example, this case would have been an appeal by you only had the trial judge included an amount for the appeal. That's what this case would have been. But the only reason this case is here on this issue is because there was the trial judge's order which did not deal with that particular issue. That's the only reason it's here.
And that's right, because in Fríoló 2, that issue was decided in Dr. Frankel's favor. that the fee award on remand was not explicated in sufficient detail.
Get my point. My point is, you were dissatisfied with the amount, and so you took the appeal.
In Friollo too.
Right. The reason the cross appeal was taken, and could legitimately be taken, I think, in his view, is because the trial judge didn't deal with the appellate work.
I don't know if they're necessarily tied together like that. If Dr. Frankel had not appealed, they wouldn't have appealed on the...
No. My only point is, had the trial judge awarded something for the appellate work, that would have been an award that these folk would have been really hard-pressed to appeal.
Maybe, maybe not. It depends on the amount.
Well, depending upon if he goes through all... Remember now what we said in 301, the amount isn't the big thing. It is, did you go through the proper steps? And they'd have to look at whether the judge went through the proper steps. If the judge went through the proper steps, no matter what the amount, they are really a little bit... They're going to be somewhat cautious about taking the appeal. But on your case, you would have taken it anyway because you were dissatisfied with the amount.
I don't think that it was that we were dissatisfied with the amount. It's that this court said, Judge Beard, you need to do X, Y, and Z on remand, and Judge Beard didn't.
The amount didn't mean a bit of thing. It didn't make a difference at all. It really was not a matter.
If the order set out, if the order did what it was supposed to do, it would have put us in a much different position.
Okay.
And that order really puts this case in a box.
Okay. Mr. Goldsmith.
Let me pick up on a couple of things and start by tying in something that Mr. Fote argued early in his argument and what the court's dialogue with him just got into. He said that if folks get representation, the purpose of the statute has been vindicated, and the way in which he said it was to make it retrospective. In other words, everything's okay here, even if Ms. Friollo doesn't get compensation for all of this effort that was involved in trying to get her the benefit of the result that she obtained at trial, which was to prove that Dr. Frankel had not paid her wages. Everything's okay because she had counsel here. That's not vindicating the purpose of the statute. What's vindicating the purpose of the statute is if the next Joy Friollo who comes along can also get counsel. And the only way that that's possible, and this court has said it twice already now, we're only asking that it be repeated a third time for the benefit of the trial court. The point is that the next person who comes along who has a low-wage case or a security deposit case or that sort of case should be a discrimination case, should be able to get counsel so that, and because it is the ability to actually continue to have private attorneys general bringing these cases that vindicates the purposes of the statute. The fact that retrospectively someone had an attorney, trust me, I'm sure all of you would agree that lawyers will be reading what the outcome of this is, and if they see that it's impossible to be vindicated, even when you win, even when the result of the case that the plaintiff brought is the enunciation by this court of statewide law on an issue of great importance under many different statutes, the message will be clear. Don't bring these cases. And that's precisely what the legislature was trying to avoid and what this court has acknowledged the legislature was trying to avoid. And indeed, as Chief Judge Bell's question implied a moment ago to Mr. Fote, there's no need for extra rules to be generated here to discipline plaintiffs and their attorneys from bringing these kinds of cases. Indeed, the defendants can bring an appeal at no extra cost, at no extra danger to them if they don't like the amount. In the plaintiff's case, there are no fees if the plaintiff is wrong and the plaintiff does not receive a successful result. I want to add to that I think one of the aspects of the result, there's been a lot of focus here on what the dollar amounts are here. Another big aspect under the 1988 cases and this court's case are the non-financial aspects of this, which involve the public effects of the litigation or any other impacts that are not strictly financial. And I would argue that the fees that are before this court now were very important. The fact that Ms. Friollo took the appeal and Friollo won I believe, has been of aid and will continue to be of aid to many other low-wage people and others who are entitled to fee shifting under remedial statutes in this state because of the result that was reached there. I think that that's a very important point that we shouldn't overlook. Now, there was some discussion about the Court of Special Appeals standard and the idea of proportionality or disproportionate. I would just like to address that briefly and just say that I believe that upon a careful reading of the Court of Special Appeals opinion here, the concept of proportionality or disproportionality either is directly in conflict with what this court held in Fríola 1, which is that we don't do a cost-benefit analysis to decide what the reasonable attorney's fees are, or if it's not that, it's completely incoherent and must be vacated for that reason. There is no alternative explanation of what the proportionality means. Proportion of what to what. I take it that they were saying that it's a question of whether the fee was so low in relation to the damages that would make it grossly disproportionate. That would be contrary to Fríola 1. If that's not what they meant, I don't know what they did mean, and the decision needs to be vacated and reversed for that reason. Mr. Fote also, he made a couple of arguments about, we went back into this area of the ethical rules, rules of professional responsibility and how they might impact this. Let me point out that he brought up 1.7 and 1.8. He waived that. He didn't brief it at all before this court. Let me add also that he raised the question of the Sterling case. Judge Mason in the Sterling case was presented with a particular, as this court suggested in the Fríola 1 case, Judge Mason got a fee agreement before him. When he reviewed the fee agreement, he recognized that depending on how he adjudicated the fee shifting, he might actually directly harm the plaintiff in that case. And he fashioned a remedy to avoid that while simultaneously providing any extra benefit to the wrongdoer in the case in doing that. That's nothing like what Mr. Fote is suggesting here. Here, what they're asking for is really for the defendant to become some kind of a third-party beneficiary of some alleged misdoings, misdeeds by plaintiff's counsel towards plaintiff. There are no misdoings, there are no misdeeds, and there's no basis for them to become the beneficiaries to gain from some kind of argument that Ms. Fríola shouldn't have brought this appeal when indeed she succeeded in the appeal and helped to develop the policy of the state pursuant to this court's opinion. With regard to the Pak case, again, Mr. Fote argued that there was an issue of that he focused on the issues of the willfulness and the contempt because he read from the questions presented, and indeed those were questions presented in that case. However, read the conclusion, read this court's holding. The holding was not about contempt. It was not centered on willfulness. There was some mention of it, but it was not centered on contempt. It was not centered on willfulness. It was a statutory ruling that under the security deposit statute, the fees were available both for enforcing the judgment at the trial court level and for trying to obtain attorney's fees that were necessary in order to enforce that judgment on appeal. That's exactly what we're asking for here. No difference. Going back to the questions about whether the Franco parties somehow that this is a once-in-a-lifetime case and that somehow they're in this unique posture, the posture that they're in terms of their potential exposure here is a posture completely of their own making. They staunchly disagreed at the trial court level initially that the lodestar method should be applied by the court in adjudicating the fees. They were wrong. They lost. On appeal in Fríola 1, when that question came up, they continued to argue, and I'm quoting now, that appellant's assertion that such discretion requires an award of fees determined by the lodestar approach is simply incorrect. So they're arguing it to the trial court. They're arguing it again on appeal. And yet they're saying that the whole problem is that the court has made an error that they're going to have to pay for, but they urge that error.
It's not unusual for appellants to disagree with trial court ruling. You did.
That's true. That's true. But Judge Castle, that's completely fair. However, I think it's important to note that the statute contains no language and no gloss that I'm aware of that's been applied by the courts that says that somehow this is a willfulness standard or a intentionality standard or something, that they have to litigate a certain way in order to be exposed to possible payment. No, they have to pay the shifted fees because Dr. Frenkel cheated Ms. Friolo out of her wages. They could have paid the wages immediately upon receiving a demand way back at the beginning of this, and there would have been no or virtually no attorney's fees. Could have been no attorney's fees if they had not violated the law.
Well, except for the claim of 5% of his practice.
Well, which came after he had not paid her wages, Your Honor. But and I would just add, just as a postscript to that, I think if Your Honor can see in our brief that was not a major issue in the case at all. It was not mentioned or at all at issue in the pretrial statement, which was 5 or 6 months before the trial ever happened. It's a red herring. It should not be the basis of where the court goes with this. I want to thank the court very much for its time.
Thank you all.
Thank you.
All right.